Well, good morning and welcome to the May 17, 2018 public meeting of the New York City Campaign Finance Board. The first item on the agenda for this morning is the approval of the minutes from April 12, 2018. I'll move their approval. Is there a second?
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? Motion carries. Also on the agenda for today's meeting will be an appearance by one candidate. Right, that's right. It's just one from the 2013 elections. Later today, the CFB will testify before the City Council regarding our fiscal year 2019 budget. Please tune into that hearing for more details on our ongoing work on the 2017 elections and plans for the 2021 election cycle. At this time, I would like to welcome our newest member of the board, Ms. Marianne Spraggins. Ms. Spraggins was appointed on February 26th to serve a 5-year term ending on November 30th, 2022. Ms. Spraggins has held a distinguished career as an investment banker, entrepreneur, attorney, and as a public servant. She previously served as director of the Securities Investor Protection Corporation under President Bill Clinton and as senior counsel at the Congressional Oversight Panel created by the United States Congress in response to the 2008 financial crisis. She also served on the executive committee of the Democratic National Committee in 2008, and here locally, Ms. Spraggins has served as a member of the board of directors of the New York City Economic Development Corporation, the New York Law School, and the Apollo Theater Foundation. On behalf of the board, I'm proud to welcome Ms. Spraggins to the CFB. Her extensive career in public service and finance will undoubtedly serve us well, and I look forward to working with her to strengthen New York City's democracy in the days ahead. As we welcome Ms. Spraggins, we're also bidding farewell to Mr. Art Chang, who served as a member of the board for 2 full terms and nearly 10 years since his appointment in 2009. Mr. Chang was the founding chair of the Voter Assistance Advisory Committee and played a critical role in developing the NYC Votes initiative to educate and engage with voters. Mr. Chang's many contributions to the CFB, to candidates, and to the voters of New York City cannot be quantified. Art, thank you for your years of service to the City of New York. With that, I will turn to our Voter Assistance Advisory Committee Chair, Naomi Zauderer, for her report.
Thank you, Chair Schaefer, and welcome to the board, Ms. Spraggins. Monday, May 21st, is Student Voter Registration Day. Partnering with the Mayor's Office and the Department of Education, NYC Votes is ramping up efforts to reach potential new voters by registering young people at every high school throughout the city. The Voter Assistance Advisory Committee held its biannual public hearing at the beginning of May. At the hearing, voters had the opportunity to listen to a panel discussion between 3 experts on New York's election system and the future of electoral reform. Moderated by Eric Friedman of the Campaign Finance Board, the panel discussion included Esmeralda Simmons Esquire of the Center for Law and Social Justice, Alex Camarda of Reinvent Albany, and Perry Grossman of NYCLU. Thank you to all of these individuals for participating in a lively discussion about our election system and the path to making it more fair and accessible. The hearing followed the release of NYC Votes 2017-18 Voter Assistance Annual Report. This report covers voter registration and election turnout data collected from the 2017 citywide election. A key takeaway from the report is that New Yorkers care deeply about their elections and want to participate more than ever. However, our outdated election laws prevent many of us from reaching the ballot box, driving down voter turnout in local elections. Nevertheless, there are common sense pieces of legislation that could help mitigate this problem, which brings me to my next point. Just over a week ago, NYC Votes traveled to the state capitol in Albany for an inspiring day of advocacy on behalf of voting rights legislation, including legislation to have New York finally join the 37 other states who have early voting. This marked the 5th anniversary of Voter Day, providing the opportunity for hundreds of New Yorkers to learn firsthand about citizen advocacy. Throughout the day, our dedicated staff and hundreds of volunteers met with legislators and staffers from over 40 state Senate and Assembly offices as part of our campaign pushing for electoral reform. We're thankful to all of the volunteers and partner groups who contributed to the event, and we hope you will continue your advocacy efforts going forward. There is still time for New Yorkers to join us in this effort, first by signing the petition at votebetterny.org. With that, I'll turn to CFB Executive Director Amy Loprest for her report.
Thank you. I want to say that after 30 years of it being in existence, our program continues to be a model throughout the country, and I had the opportunity over the past 2 weeks to give evidence about the success of our program in 2 venues. First, 2 weeks ago, I testified before the Illinois House of Representatives on a bill that is modeled after our small dollar donor program that the Illinois state is considering applying to their legislative offices. It was a very interesting discussion about the success of our program and how that it can, in application, can actually be a beneficial program for democracy. And the legislators were very appreciative of my testimony. Also, last week, I gave a presentation at a national conference, for the National Institute of Money and Politics, before a group of advocates and funders and administrators of programs across the country about our program, and they were very, very interested in how our program has been successful in increasing the number of small donors and increasing the diversity of representation in our democracy. So we should all be proud of the 30-year history of our program, and it continues to be a national model.
We look forward to an invitation from the United States Congress.
Let's not hold our breath.
Yeah.
You done?
Yep.
All right, we have one candidate appearance today. So if the attorney for the CFB and for the candidate would please take your seats. I think Mr. Laufer knows the drill. We're going to ask the CFB attorneys to sort of present a summary of the issues, and then the floor will be yours.
Good morning, Chair Schaefer, Executive Director Loprest, members of the board, and Mr. Laufer. My name's Cameron Ferrante. I'm Associate Counsel for the CFB. With me today is Danielle Williman, Deputy Director of Audit for the CFB. Before the board is the matter of the Peter F. Vallone Jr. campaign in the 2013 primary election for Queens Borough President. The candidate was a participant in the program and received $655,488 in public matching funds. CFB staff recommends the board find that the campaign committed the following violations of the Act and board rules and assess penalties in accordance with the 2013 penalty guidelines. Failing to file and late filing of daily pre-election disclosure statements, failing to demonstrate compliance with subcontractor reporting and documentation requirements, accepting over-the-limit contributions, accepting contributions from corporations, limited liability companies, or partnerships, accepting contributions from unregistered political committees, failing to document transactions, failing to demonstrate that spending was in furtherance of the campaign, making impermissible post-election expenditures, and exceeding the expenditure limit. CFB staff further recommends that the board find that the campaign must repay public funds. The campaign has contested the recommended violations, penalties, and public funds repayment. Thank you.
As we understand it, many of these are uncontested. And
Yeah.
There's one contested penalty, and also contested is the repayment recommendation.
Correct.
Do you want to address those now, or would you rather wait until Mr. Laufer has spoken?
I'm happy to wait until Mr. Laufer has spoken.
Mr. Laufer, the floor is yours.
Good morning. I am Lawrence Laufer. I'm representing the 2013 Vallone campaign, which was a campaign for Queens Borough President. I have additional copies of a letter that I submitted to the board, which is dated May 11th, I'd like to hand those up.
We all have copies now, so it's unnecessary, yes.
Before you go, I just have one question. On page 2 in your letter, you underline respondents are not directly contesting the allegation of expenditure limit violation. Having read the rest of your letter, I was somewhat confused by that. Are you contesting that that Mr. Vallone exceeded the expenditure limit or not?
Our argument regarding the expenditure limit, which I'm going to get to second, is simply an argument for the mitigation of the penalty to zero.
So you're arguing mitigation, not that it's not a violation.
We're not contesting the board making a finding of violation on the spending limit. Our argument is simply to mitigate the penalty to zero.
Okay.
I'm first going to address the claim for overpayment. This, just so you could follow along with the argument that I have to present, it's covered in my May 11th letter at pages 7 to 9. This claim for repayment stems entirely from a deduction of $60,000 in public funds due to a $10,000 transfer. And again, that's $60,000 in public funds due to a $10,000 transfer. Now, the board currently has no rule in effect that would permit a $60,000 deduction for a $10,000 transfer. The relevant rule here is Rule 501N, which is currently in effect, provides for a maximum of a $10,000 reduction, which if the board follows the rule as it currently is in effect, there would be no claim for overpayment. Now, the city's campaign finance laws and the board's rules are frequently amended, and in general, those amendments are prospective in effect. So to give you one example of what I mean by that, in December of 2016, the City Council enacted a number of laws, one of which was Local Law 194. This is the law, and I'm sure this board is familiar with it. It amended the procedures for board deliberations. And that was a law that went into effect immediately. So what the effect of that law was that the procedures governing board deliberations in cases involving the 2013 elections, such as this one, differ according to whether that proceeding occurred prior to the effective date of Local 194 or occurred after that effective date.
Isn't that true? Because if, in effect, the deliberation is a transaction which is taking place after the new law. Well, here, isn't it a situation where the transaction that is at issue took place when the old rule was in effect?
Actually, I agree with your analysis, but not your conclusion. The transaction that is at issue here is a board repayment determination.
The transaction is the impact of the transfer of certain funds, and what is the impact of that? Isn't that the relevant transaction?
The transaction that you're evaluating concerns this $10,000 transfer. However, the action that is being taken is an repayment claim. What the board has to do is make a final determination on repayment. That is a determination that's being made today under the law and the rules that are in effect today.
Based on acts that took place under the old rule. Frankly, I don't quite follow your argument.
Well,
let me sort of underline the point. If we had an identical candidate to yours or a candidate who was in the same situation, whose proceeding reached the board in 2016, then according to your interpretation, the old rule would apply. But because your proceeding has come to us 2 years later, even though the transactions both occurred at a time when the old rule is in effect, you're saying that your transaction gets treated differently because it took a long time for this matter to get to the board.
actually what I'm saying is the board's repayment claim gets treated differently because it's first being made after the rules have changed. So
I think you sense a certain degree of skepticism, but go ahead.
I'm confident of prevailing on this point. I'm going to proceed.
Okay.
When the board has wished to depart from the prospective effect of its rule changes, it's spoken very clearly. In fact, when the board wishes to depart in any way that's based on a basis other than prospective effect, for example, this is a document called the 2013 CFB penalty guidelines. It's clearly denominated as being for the 2013 elections. Here's another document. This is called the 2017 penalty guidelines. So here we have an example of the board applying one set of standards to the 2013 election and a different set of standards to the 2017 election. Turning to the rule change, when the board amended its rules in December of 2016, and this again is Rule 501N, it did not make any distinction, such as the kind that it made here, between the applicability of these rules changes on the basis of an election cycle. It only made a distinction on the basis of effective date. The old rule was in effect for payment determinations or repayment determinations prior to that effective date, and the new rule is in effect for subsequent payment determinations. Now, I agree, this overpayment claim against the Vallone campaign is now before the board for the very first time, and this time is 17 months after the rules were changed. The CFB staff had ample time to initiate this proceeding in 2015 or 2016 when the former rule was in effect, and it chose not to do so. So the board has to address the fact that the overpayment claim that the staff is recommending is actually contrary to the rule that's currently in effect, and even more importantly, it's contrary to the public policy that the board enacted in its December 2016 rule change. What the board stated in changing the rule was, quote, "This eliminates the disproportionate burden on participants who make 501N expenditures that results under the current, now former rule due to a 6-to-1 matching ratio." So the issue that I submit the board has to consider on this repayment claim is, given that the board has long ago eliminated what it called a disproportionate burden on participating candidates, I submit it would be arbitrary, capricious, and an abuse of discretion and ultra-virus for the board to effectively reenact the repealed rule solely for the purpose of imposing that disproportionate burden.
You've indicated some skepticism as to the premise of your argument. Is it clear that if the new rule applied, that the penalty would be $0 as opposed to $10,000?
It's not a penalty, it's a repayment claim.
Or, the repayment would be $0 or $10,000?
I believe that's crystal clear, but I'll defer to Mr. Ferrante on that point.
Yes, it would reduce it to 0, effectively.
Unless there are further questions on that point, I will move to the expenditure limit.
Would the board like me to respond before we proceed to an additional argument?
If you don't mind,
No,
be helpful.
no problem.
Let's finish this issue and then move on to the other.
Okay, so, Mr. Laufer has made a case that applying the rule retroactively as he deems it would be arbitrary and abusive discretion.
I'm sorry, I object to his reference to my argument being retroactive. It's not.
We did let him make his argument.
I view this as a matter of fundamental fairness. While I don't doubt that Mr. Laufer would be making a similar claim had the rules change resulted in an increase in the repayment obligation, I think that applying a different standard to a 2013 campaign just because of the date on which it has proceeded to enforcement, as opposed to the rules that were applied to all the other 2013 campaigns similarly situated, as Chair Schaefer referenced, would itself be arbitrary and capricious. In terms of Mr. Laufer's reference to CFB staff's election not to pursue enforcement in 2015, I don't believe, and I, as a CFB staff member, have never made an enforcement decision based on potential prospective rules changes and the impact that that might have on a penalty. So I don't believe that the rule that the CFB staff elected not to proceed in 2015. I believe that this campaign in particular presented numerous factual and legal issues which took time and a lot of man hours to address and fully evaluate, which resulted in the delayed proceeding we now encounter. That's really all I have.
I think the two sides of the argument have been adequately presented. I mean, my own view, Mr. Laufer, is you began with the example about the change in the law concerning our procedures. And obviously, once that is in effect, our procedures have to change with respect to who's present during our deliberations. That's the relevant transaction. But as Mr. Davis and I have indicated, here we think the relevant transaction under the rules is how do you treat a particular event, and at the time that that event occurred, the old rule was in effect. And so that seems to at least two of us that's the relevant transaction. To me, the issue isn't retroactivity versus prospectivity. The issue is how do you define the relevant transaction? You're defining the relevant transaction as the board's decision to seek repayment. We don't see it that way. We see the rule as referencing how you characterize a particular transaction that occurred when the old rule was in effect. And I think, issue has been fairly joined on that.
Mr. Schaefer, I would just point out that the Vallone campaign didn't advocate for this rule change. The board chose to change the rule because of what it felt was a disproportionate burden on candidates. The Vallone campaign didn't delay this proceeding so it wouldn't be initiated. You, as a board, now have to consider, after you've established a new public policy that I would say is a wiser and fairer public policy for candidates, whether you're now going to turn back to policy that you had identified, again, without my client's advocacy, as being unfair and disproportionate.
Yeah. Let me just quickly respond in two ways. One, this is hardly the first time that we're faced with an issue where the board has changed its rules. Sometimes, even though there have been rule changes, we apply the old rule to events that occurred when the old rule was in effect. And there's nothing unfair about that. That's just how things sort themselves out. And I forgot what the other point was, so I'll just stop there.
All right, well, I'll proceed to the spending limit. Again,
the other point was that the new rule is actually more lenient in some respects, but harsher in others. And so while you may view it in this particular case as curing a disproportion, it actually creates, at least potentially, a disproportion on the other side. So the new rule is an attempt to come to a better balance in an extremely technical and complicated area. It has, depending on the facts of the case, it could have upside or downside
I understand
effects.
the risk I run in asserting the argument. It is simply the case that the board is making a payment determination in 2018, and that is the basis of the argument.
We got the point.
Okay. The second issue, which is covered on pages 1 to 7 of my May 11th letter, so I'm going to try to be brief in the summary, concerns the assessment of a penalty for the spending limit. And our argument, as I clarified to Mr. Davis, is for mitigation of that proposed penalty to zero. The staff's calculation shows that the respondent campaign underspent the aggregate $1,579,000 spending limit by approximately $100,000 due to the campaign's effort to comply with the Campaign Finance Board staff's directions concerning both Advisory Opinion 2008, number 7, and regarding the District Attorney Exploratory Committee. As we understand it, the staff is now recommending a sanction because the respondents' efforts to comply with both that advisory opinion and the staff instructions regarding the exploratory committee fell short by either $2,536 or $8,286. And the details on that distinction are actually immaterial to the argument I'm presenting. Now, respondents are submitting that this alleged shortfall in compliance is trivial and therefore appropriately mitigated to zero in light of the concerns we have raised regarding that advisory opinion and regarding the staff's conclusions about the district attorney exploratory committee. And I just want to summarize why we believe these concerns recommend to the board that the penalty be mitigated to zero.
Ms. Laffer, before you get to the substance of the argument, I'd like to know whether you're aware of any case where the board has mitigated to zero a penalty on an overspending violation.
I think the board has.
Here, I mean, as you know, the penalty can be a multiple of the amount overspent. Here, the board is simply recommending 1 times the amount. And I'm curious, since you obviously have in your head some history of this board, whether you're aware of any instance where the board mitigated to zero an overspending violation.
I will put it in these terms. Right now, the recommendation of staff has neither aggravation nor mitigation associated with the calculation. It's based on a standard in the 2013 penalty guidelines. So the argument I make moves us from the standard. First of all, the board has frequently mitigated spending limit penalties. That there's no question that there's precedent for mitigation in general. Secondly, I can tell you that there are instances where the board has mitigated other proposed penalties on violations to zero, where they have made findings of violation and reduced the penalty to zero. I don't know of a distinction, frankly, as to why spending limit would be treated differently than a practice for other types of penalties in terms of potential mitigation. So I don't think the board is constrained to mitigate it to zero. So if we get back to this issue of retroactivity in talking about Advisory Opinion 2008-7, I don't think it's disputable that that advisory opinion retroactively changed the spending limits that are applicable in the 2013 election for some 2013 candidates, and this was called Group 2.
You say retroactively. I don't quite understand that word in this context when you're talking about an AO in 2008 for candidates to make an election for the 2013 candidates. I don't understand the word retroactive.
The change that the 2008 opinion made, and I don't believe you were on the board at the time, applied to expenditures that were made prior to the date of that opinion. That's what I mean by retroactive. It wasn't simply speaking about expenditures that were made after that opinion was adopted.
But it made that change only if a candidate made a particular election. That is to say, your candidate and other candidates were not required to freeze their committee. They could have chosen the other option, well, let me just leave it at that. Your client chose an option that had a particular condition attached to it.
Yes, that is correct. And the condition concerned expenditures made prior to the date of that opinion. We're not disputing the notion that my candidate, my client, made a choice. This change regarding the expenditures for the 2013 cycle was never adopted into law. It wasn't adopted into the CFB rules, and there was 5 years' opportunity to do that. Further, the change made by the 2008 opinion with respect to the 2013 election was not challenged by the plaintiffs in the Kurland litigation. The Kurland plaintiffs challenged what had been the advisory opinion's loosening of expenditure limits for the 2009 election. They didn't bring a challenge to what was a retroactive temporal expansion of the spending limits for the 2013 election. Now, the sole express purpose stated in that advisory opinion for the change was, quote, to level the playing field. And the method of leveling the playing field that's applicable to respondents is by imposing this additional 2013 limit on the Group 2 candidates. Just over 2 years later, in 2011, the United States Supreme Court struck down the level playing field rationale for penalizing speech of some candidates for the benefits of other candidates.
Right, and that was in a case where the court found that the rule infringed the right of free speech. What is the infringement on the right of free speech here?
Buckley versus Vallejo established that campaign expenditures are protected under the First Amendment as speech. So in campaign finance terms, we're talking about interchangeable issues.
That's not what Arizona holds. I mean, in the Arizona Free Enterprise case, the court characterized as a penalty on free speech the increase in the match because a non-participating candidate was spending at a certain level of money. That's the First Amendment violation. I don't understand where you see a First Amendment violation here. I understand that the court refused to accept the level of playing field as a compelling state interest in light of that, what it viewed as a penalty on free speech. Where's the penalty on free speech here?
The board is considering either a $2,600 or an $8,200 penalty. Where the only issue before the board today is the imposition of penalty. That's why I'm arguing for mitigation.
But Mr. Laffer, your client made an election to use this money for the 2013 election. Your client could have given back the money, right?
Mr. Davis?
Yes or no?
Didn't
have to use it.
I mean, I suppose my client could have done anything. What I'm getting at is the act establishes spending limits.
No, but what you're saying is that your client could take half of the loaf, but not take the whole loaf. You're saying your client could take advantage of the ability to use money in a later campaign, but not take the other part of the election of having something attributed to your expenditures it's relating to what was raised, money that would cost to raise that money. How does that make sense?
I think the starting point is, what does the Campaign Finance Act do? It imposes spending limits as a condition for receiving public funds.
Right.
Though the act defines the time periods of those spending limits. We have an advisory opinion in 2008 that changed the applicability of those spending limits for certain candidates.
If they chose, if they made an election.
If the advisory opinion hadn't been adopted, and this is very clear, there's a footnote in the advisory opinion itself. If the advisory opinion hadn't been adopted, none of those expenditures that are at issue today would have been subject to spending limits for the 2013 election. The only basis for
What would have happened to the money raised?
He was free to raise it and claim it for matchable contributions. I covered this in the letter. Had the status quo prevailed, if there had been no advisory opinion, the Vallone campaign, this committee that was established in 2005 or 2006, that ultimately was utilized for the 2013 election, could have started fundraising in 2005 and 6 as it did, raised that money under limits that came into effect for the 2013 election, spent freely until we reached January 1st, 2010, and then it would come under limits associated with that election, and those funds would have been claimed for matching when we get to 2013.
But what I'm getting at is you're asking for mitigation. Mitigation suggests that something unfair happened. And why, and since you're asking for mitigation, my question is really, why is it unfair that costs associated with raising money count towards the limits? Why is that unfair? Because that seems to me to be the basis for mitigation.
I'm not arguing about what's fair or unfair. The Supreme Court has said that's unconstitutional in this context. The argument that I am making...
interject, the Supreme Court hasn't made any holding related to...
You'll have a chance.
Don't interrupt.
Okay.
The argument I am making concerns the imposition of penalty, exactly as Mr. Schaefer framed the Arizona case. That was a question of whether it was appropriate to penalize a candidate for spending. That was the issue in the Arizona case. The board is now faced with precisely the same issue. We are talking about a different local law.
Anything. We're talking.
I mean, this isn't a penalty. This is not a penalty on a free speech right to spend. This is simply a question of how you allocate expenditures, and when you talked about leveling the playing field, what the board was saying in its rationale for the advisory opinion is that here is some candidates will, because they froze their committee and then chose to use that money in 2013, they will have the benefit of having that money to be able to use in 2013, and therefore should have attached to it the associated expenditures related to the raising of the money. Otherwise, they get an advantage over candidates who didn't have a frozen committee back in 2009.
Mr. Schaefer, with all due respect, there was no benefit that was granted by that advisory opinion in terms of the ability to use those funds for the 2013 election. Had the advisory opinion not been issued, the law that governed that circumstance is those monies were usable in the 2013 election. Though candidates can establish a political committee for a future election at any given point in time, the law doesn't confine you to establishing it within a 4-year election cycle. So if the board had not addressed the term limits change, and the Vallone campaign ended up doing exactly what it did, which was utilize this committee that had been established in 2005, none of those expenditures that are now at issue under this advisory opinion would be subject to the spending limits. So the board was not granting any kind of new benefit in terms of allowing these monies to be utilized in terms of the monies raised, the monies spent in the 2013 election. The board was interposing what it rationalized as something that would make things more fair among candidates who faced off first in the 2009 election and then in the 2013 election. And my point is simply this. When the 2008 board came together and said, here's what we think will be fair going forward, part of that judgment singled out this group 2 for an extension of spending limits to cover expenditures prior to the time of the advisory opinion. And the rationale for that was we want to lower what these candidates can do in order to make it fairer for their future opponents in the 2013 election. That is the level playing field justification. Today, the only question before the board is whether to penalize the Vallone campaign because it didn't perfectly adhere to that effort to level the playing field. It missed the mark.
To which they agreed when they made the election.
Mr. Schaefer, we're not looking to argue out of what was agreed. The context for our argument is this issue of substantial compliance. They tried to comply with that advisory opinion. They fell short of complying with the advisory opinion. The effect of the effort of complying with the advisory opinion was underspending the limit within the confines of the cycle by approximately $100,000. At the same time, the justification for the change made by the advisory opinion, like it or not, in 2011, the Supreme Court threw out the justification, the very words that the advisory opinion uses. And what I asked the board to consider as mitigation is that you are looking to penalize, whereas I don't fault the 2008 board for trying to do something that they thought would be fair and not anticipating what the Supreme Court would say 2 years later. I would urge the board that it not ignore what the Supreme Court said in 2011 and consider mitigation on the basis of the constitutional argument. Now, the final points concern the District Attorney Exploratory Committee. And I will just say the underlying beauty of what I'm arguing is the board doesn't have to give a ratio decidendi, if that's the right word, for the mitigation that I'm arguing for, because whether it accepts the point on the advisory opinion or it accepts the point that I'm about to make on the district attorney exploratory committee, either one standing alone would eliminate the penalty. So, regarding the exploratory committee, respondents were permitted to authorize a separate political committee under state law for the purpose of exploring a race not covered by the Campaign Finance Board. And as we've submitted, this concerned potential race for district attorney should an opportunity arise for him to run, such as a vacancy. Respondents concede that errors were made in administering the district attorney exploratory committee. And we also concede for that reason that it's appropriate for the CFB to charge some of the expenditures that the 2013, some of the district attorney exploratory expenditures to the 2013 campaign. And that was the purpose of Exhibit A to my May 11th letter. We crossed out the ones that we're not contesting. So that leaves an amount in dispute of about $18,000, which exceeds the one-to-one penalty that's been proposed. And most of that $18,000, over $16,000, was incurred between September 11th and September 2011 and January 2013. That was a time period where the Borough President Committee was not actively raising any money. And indeed, the CFB staff has concluded that the consulting fees, the fundraising consulting fees incurred by the district attorney exploratory committee during that period of months, that none of those are attributable to the 2013 election. So we simply submit that we believe it's excessive for the CFB staff to recommend that 100% of the $18,000 that remains in dispute, which were for purposes such as utilities, office supplies, rent, accounting and compliance, and telephone service, that 100% of that $18,000 is subject to the 2013 Borough President limit, because the CFB is otherwise treating only 17.9% of the other expenditures that had been cited in the audit as subject to the 2013 limits. We submit it would be disproportionate for the board to penalize on the basis of a so-called election cycle presumption, that to in effect treat that presumption as conclusive about the 18,000, because the audit has otherwise concluded that only 17.9% of approximately $58,000 in exploratory committee expenses are attributable to the 2013 election.
Mr. Laffer, in that regard, though, isn't the burden on your client to come forward and show item by item adding up to that $16,000 and change, which campaign the expense related to? And if you had done so, wouldn't it make us more sympathetic to the argument that you're making? But instead, you've made what is sort of a clever, logical argument about why it shouldn't be attributed, but in the absence of evidence, I'm not sure how we rule.
Well, there are actually two avenues for making the demonstration that I'm discussing, and you have described one of them, which is document by document. And to the extent that that hasn't been provided, there may be documentation deficiencies that are associated with separate penalties, but we're not looking, I assume the board would not be looking to penalize a mere documentation deficiency as a spending limit violation. But the second avenue is one that the staff itself identified, which is reasonable apportionment. That was the guidance that was provided to the Vallone campaign throughout. And so even if the board were to depart from the 17.9% that we were able to demonstrate concerning the other expenditures, even if you were to bump it up to 50% and saddle the 2013 campaign with a 50% charge, it would still eliminate the spending limit penalty.
Right, but you're relying pretty much entirely on the fact that during that time span, no fundraising activity was going on. But these are not expenditures that necessarily relate to fundraising. So wouldn't we also need to know whether any other campaign activity was going on relating to the borough president?
And yes, and your auditors have made those distinctions. The expenditures in this time period, as to a large degree, are ongoing in-house costs for rent, accounting, compliance, office supplies, utilities, telephone service. Most of it was of that nature. So to the extent that there's a conclusion that 0% of the fundraising, which was the major activity during that time period, is certainly reasonable to conclude that there's, you can conclude that 0% of these overhead costs during that time period. But I don't think the board has to go that far. If it merely goes to 50%, it eliminates the penalty. So these are our two arguments.
If you don't mind my interrupting, and I'll let you come back for a peroration at the end. On this very last point, I'd like to hear the CFB staff's response, to whether how we allocate these kinds of office expenses at that point in time, and who's got the burden of showing what.
Well, the burden rests on the campaign to demonstrate that any expenditures by an authorized committee aren't related to the covered election. In this case, the campaign adopted an 80%, 20% difference or allocation as part of its development of a reasonable methodology, which we accepted, and the campaign then failed to demonstrate that methodology applied to these $28,000 in expenditures. Essentially what's happening now is the campaign's asking for credit for admitting that 10,389 or something in that range in state committee expenditures are attributable to the campaign, to say that that then provides a reasonable ratio of the remaining expenditures is both contrary to the 80-20 split that they adopted and agreed to demonstrate, and also just giving them credit for admitting that the state committee expenditures applied to the campaign.
Help us out a little bit, because it's always a bit of a problem for those of us who've never actually participated in one of these audits to figure out really at the grassroots level what's going on here. What is it that they should have provided you and didn't that would have supported the 80-20 allocation?
I believe that's a question for you.
So we were missing a lot of invoices. There were times when the 80-20 methodology wasn't followed, so we wouldn't accept that. And then there was also times where we either didn't have invoices to show that the 80-20 was followed, or based on the other expenditures that were reported to us for the 2013 committee, we couldn't reconcile that 80-20 percentage. And then there were times where the 80-20 just wasn't followed, so we couldn't accept those as well. That was the majority of the ones that we didn't accept. Yeah.
When you're doing your work and you find that the allocation that a campaign has made isn't supported or isn't fully supported by the documents you're looking at, do you construct an allocation of on behalf of the CFB as to what you think the allocation really was?
I mean, not in this case, because they were telling us what their methodology was, and it appeared reasonable. It was a reasonable methodology based on the expenditures that we were seeing from the 2013 campaign versus the state committee campaign, and also the contributions received. There were times when in 2013, they did start to move away from the 80-20 methodology, and we saw some 33-66%, which was never officially communicated to us, but it was in invoices that we saw from, I believe it was a consultant or I don't have the name down, but and we followed that because, again, it made sense based on the whole situation with the both sides spending, both sides contributions that we were seeing. So we were very reasonable and when we were going through this, and we didn't always stick to the 80/20 as a rule, but during the time period where the 80/20 made sense, if something didn't fall into that category, or there wasn't enough documentation to support that it fell in that category, we did not accept that.
But in view of the fact that you thought in general the 80/20 was reasonable, although they didn't always stick to it strictly, what more could they or should they have done to justify the fact that these expenditures could not have been 0-100, but if they weren't 80/20, they were 66-33 or something like that? What's your response to Mr. Laufer's point that it can't be 100%?
So documentation or some other explanation for specific transactions, we would definitely have considered.
But this is general overhead expenses. So you've got an office, you've got paying electrical bills, okay, and the office from time to time is engaged in two separate functions, one for a campaign for borough president and one for a campaign for DA. And the only way it seems to me to allocate it is to try to figure out, well, what was going on at that point in time? And Mr. Laufer argues there was no fundraising going on at that point in time at all with respect to the covered election. What other evidence should he have come forward to convince you that now he's offering 50-50 even as the split? What more should he have been showing you?
So the 2013 campaign still did have to file disclosure statements. They did still have activity, so we knew that something was going on. I mean, again, if they wanted to deviate from the methodology that they presented, it would have been perfectly reasonable to give an invoice and say this was specifically for the state committee and here's why. And that is something that we would have definitely considered. But we, in most of the cases, we didn't get that documentation or explanations on a specific case-by-case basis.
Do you want to respond? I'm
Yes,
a little bit lost at the moment.
I think I can respond to this. Maybe this is the peroration. I want to emphasize we're arguing for mitigation, not for a finding of no violation. And the analogy I would give you is the forest and the trees. I think when we're looking at the trees, the finding of violation vindicates staff's conclusions about the trees. And when we're looking at the forest, which is my mitigation argument, it also vindicates the staff's conclusions about the trees. And it does so in the following way. The staff examined $58,000 in the district attorney exploratory committee expenditures, and whatever the flaws were in whatever departures the campaign made from time to time on allocation methods, they were able to reach a conclusion that only 17.9% of that $58,000 was attributable to the campaign. So whatever twists and turns about any particular document, that was a conclusion that the staff reasonably reached. We come to the remaining 18th, and by the way, that conclusion includes what we have conceded are $10,000 and change in expenditures that, we're not contesting. So we come down to the remaining $18,000, and that's where I'm not arguing against the finding of violation on this point. I'm not arguing the trees. I'm arguing the forest, and that forest is built out of the staff's conclusion about the $58,000.
If I may. So I understand Mr. Laufer's point, but the reductions in the state committee attributions that we made were largely the result of documentation produced by the campaign, which either supported the attribution or the reasonable methodology that they developed, or demonstrated that it was a different percentage, as Danielle said. The remaining issue is that the burden rests with the committee to produce documentation and to maintain documentation for both the state committee and the current campaign, the 2013 committee. And they then have to produce that documentation to rebut the presumption and take advantage of the 80/20 allocation methodology. Like, there's no way to demonstrate or accept the reasonability of the 80/20 methodology without documentation supporting the 80/20 methodology.
And if I'm trying to put myself in the place of a candidate, and not necessarily a candidate represented by expert lawyers. If I had come back to you as a candidate in this situation and I said, look, here are written statements from all of my office staff saying within this period of time, we were not only not doing fundraising for the covered campaign, we really weren't doing anything else. The only thing this office was doing during that period of time was in relation to the district attorney campaign. And therefore, all of these overhead expenses, 100%, should be viewed as allocated to the uncovered election. Would that have been sufficient, statements from employees like that?
I can't speak to sufficiency. But
Yeah, okay.
Mr. Schaefer?
If I may just say one thing. Absent that type of documentation, the presumption within the act or within the rules applies, which deems that all of the state committee expenditures apply towards the next covered election, which is
Let
why
me
it's a
ask
100%.
a mechanical question. Where do we stand on the bounce check documentation?
We don't have additional documentation on that this morning. We would submit that the documentation we've given should be sufficient for the board to recognize this was a bounce check and it was replaced. I do want to address what I think is a factual error in Mr. Ferrante's summary of what the staff did. With respect to the fundraising consulting fees, which totaled $22,500, I believe, we didn't make a documentation argument. We made the same macro argument that I'm making now, because what we showed was during the time period in which those fundraising expenses were incurred, all the money was going into the DA committee and not into the borough president committee. And we said that the board couldn't rationally conclude that those were fundraising expenses for the borough president committee when the money was not raised for that purpose.
Fair enough, but that's not a purely macro argument. You've got documentation as to where the money is going. But when you're dealing with expenditures that don't relate to fundraising, then you need some documentation other than a lawyer say so, that the efforts of the office are geared towards one campaign versus the other. And that is a documentation issue.
And as I said, I think there's a distinction between mitigation and violation in the board's reflection on that.
Just going back to the bounce check, remind me, maybe in the memo, what is the documentation we in fact have?
We have a bank statement and an invoice from the vendor in question.
And the bank statement shows?
It shows a check issued for $5,750, a subsequent overdraft, and then a returned check.
It shows the check was returned.
Actually, there's a little more than that.
There's a second check showing the fee.
Yeah, sorry, I forgot that.
There's also an email that was received from the vendor, which we provided to the staff, and it's from last week, because this is when the issue was raised with us last week, and we thank the board staff for coming forward with this issue. But so the vendor was requested to provide an invoice that would clarify what that additional $12 was. And so this is a contemporaneous statement that the vendor says, I have made the adjustment to the original invoice. And then, of course, the original invoice identifies the bounce check fee that the vendor incurred in trying to deposit the first check. So I think there's sufficient corroborating evidence, even without the insufficient funds letter, which we still hope comes in, but it's probably not in time for your deliberation.
Assuming we accept that documentation, how much does it reduce the penalty?
It reduces it from $8,286 to, well, it reduces the penalty by $5,750. So it would be, I believe,
From 8,000 something to 2,000 something.
It brings it
536.
Sorry, 2,000. Yeah, exactly.
correct. Yes.
Anything further?
I mean, if I might respond to the general mitigation argument
Sure.
regarding, I don't know if you want to hear my opinions of Arizona Free Enterprise v. Bennett. but-
Don't go back to that. But if you've got a more general point about mitigation, feel free to make
So
it.
generally, the expenditure limit is one of the clearest requirements within the Act. It's fundamental to the program, and I don't believe it merits mitigation for minor violations of it or substantial compliance. While we have in prior determinations mitigated with respect to the multiplying effect. I don't believe there's a situation in which we've mitigated for just a small violation of the expenditure limit or any other type of minor compliance issue. I mean, I think a violation of a clear-cut rule is a violation of a clear-cut rule.
I would like to just respond to it being clear-cut.
Last round.
Very last point. I would agree that the expenditure limit as stated in the Act is clear-cut. What made it far less clear-cut was that advisory opinion.
All right, well, thank you both for a lively argument, and we'll retire and let you know what our decision is.
Thank you.
Thank you. Yeah, that'd be great.
All right, the board has deliberated with respect to the Valone 2013 campaign and has reached the following conclusions. These are the alleged violation. It's what's is Mr. Laufer still around, or
No,
he left?
he left.
Okay, thank you. These are the violations and proposed penalties. One, failing to file and late filing of daily pre-election disclosure statements, $187. Two, failing to demonstrate compliance with subcontractor reporting and documentation requirements, $100. Three, accepting over-the-limit contributions, $12,830. Four, accepting contributions from corporations, limited liability companies, or partnerships, $720. Five, accepting contributions from unregistered political committees, $400. Six, failing to document transactions, $300. Seven, failing to demonstrate that spending was in furtherance of the campaign, $3,204. Eight, making impermissible post-election expenditures, $893. Nine, exceeding the expenditure limit, $2,536, for total penalties of $21,170. In addition, there's a recommended public funds repayment of $3,090, of which $318.25 constitutes the bank balance for which there's candidate liability. And the total of penalties and public funds repayment combined is $24,260. All those in favor? Aye. Opposed? Abstentions? The motion carries. Aye. Opposed? Abstentions? We stand adjourned. Thank you very much.